Now, just like students have limited First Amendment rights on school campus, students have limited Fourth Amendment rights on a school campus. Whereas in public, the police are required to have probable cause to conduct a search of someone. But in schools, school employees have a reasonable suspicion standard for conducting that search.
And that's all school employees. Secretaries to administrators.
Well, we believe that the search is probably best conducted by the administrators.
All right. Sorry, go on.
Yeah, we think administrators are usually best positioned to conduct the searches. So, for these searches to take place, and the big case here is New Jersey v. TLO in 1985, when an assistant principal had suspicion that a student was smoking. He searched the student's purse based on that reasonable suspicion and found documents and other materials that indicated the student was selling or using marijuana. And the Supreme Court ultimately found that the district was justified to conduct the search. So for these searches to take place, they have to be justified at their inception. At the beginning of the search, you have to have the right to conduct. You have to have reasonable suspicion that there was a violation of school rules. Now, these searches have to be reasonable in scope, tailored to the violation, and cannot be excessively intrusive. For instance, if you are searching a student, let me think of an example here. If you believe a student may possess drugs, and I know we're getting a little bit away from the bullying context, but I think it's important to understand the principle here. And that does not give you license to search a student phone because you are just looking to see whether or not they would possess drugs. That was your reasonable suspicion. It didn't relate to the phone.
All right. So moving back to
go ahead.
Bullying, then let's say it's you have a tip for cyberbullying. Going back to the one-to-one Chromebooks we talked about with the teachers,
exactly
happened on your devices. So, what, as a principal, what are your rights? What student rights do you have to be careful of?
Well, of course, the cell phones are the Fourth Amendment issue now.
The bane of our existence.
they are. Exactly. School rules and everything else is just pervasive in how we communicate. So the first step is whether or not you have reasonable suspicion for the search. So what is the individual's expectation of privacy and personal security? In your phone, that's pretty high. But that's weighed against the substantial interest of teachers and administrators in maintaining discipline on the school grounds. So when an administrator is making a determination whether or not to conduct a search of the phone, two factors that you have to consider are, one, what's the seriousness of the offense? Because cell phone is a personal and private device that people use to communicate with everyone. And there is a expectation of privacy in how you communicate with your family, your significant others, friends, that if the school district's just looking out of curiosity, they don't really have business to be there. The other thing that you're thinking about is the age of the student. For younger students, it's not advisable to conduct the search without contacting the parents first. Make sure that the parents are there and they approve before you go through their phone.
Like junior high on down?
I would say so. The case law hasn't set a strict line of when that would be, but generally, elementary require the parents. Closer to 18, the students can offer, their right to access a phone, and then, junior high and freshman, sophomore. That's when, you're going to have to look at all the factors to make that determination.
Okay.
Now, in thinking about the cell phone searches, let's say you do make the determination that there's been cyberbullying and you would like to search a student's cell phone. Do not go looking through everything. You don't have license to look at every single app. If you think the bullying was sent through text message, then you can only look at the text messages. If you have been informed that the bullying was sent via Facebook or via Snapchat, you should keep it to the apps that you believe were used for cyberbullying. That you only have reasonable suspicion to search those areas. You don't, just because you believe a phone needs to be searched doesn't mean you can look at the pictures or other things. That has nothing to do with what you're looking for. There's been a couple cases on this, and in one case, a student's cell phone fell out of his pocket, and because it was seen in public, it violated school rules. The school confiscated the phone, and they looked at everything. And in this one case, which is sort of on its own, the court still found in favor of the district because the student broke a rule. That was enough reasonable suspicion to search the rest of the phone. Now, that is one isolated case, and I don't think that is something the district should be relying on. In other cases, they've basically said, if you take a phone and you decide it needs to be searched, you only have the ability to search the places that you have reasonable suspicion that the bullying or the other incident took place on.
Okay. And so let's say you had suspicion that it was in Snapchat, and so you looked through the student's Snapchat and you found other instances of bullying that were totally unrelated to the current issue.
The question would be, if you have reasonable suspicion basis to be there in Snapchat and you found other instances that related to student discipline, then yes, you could use that evidence. But you would have to have a reasonable suspicion to be there in the first place. I know one issue that has come up in the context of cell phones before was when students have some kind of passcode that locks the phone and makes it unable to search without having that code. I think when that's the case and the student refuses to give you that code, the district needs to make a determination of either, one, this is a very, very serious offense and we need to find out what's on that cell phone. And in that case, we would advise contacting the police and for them to go through their procedures. But if you determine that, it's not that seriousness enough of an offense, then you wouldn't conduct the search. And I'd also like to add that in the context of cyberbullying, you're still doing the substantial disruption analysis if it's something that took place away from campus. So just because you hear about something that's going on, that does not automatically give you license to conduct a search. You're still thinking about, is this substantially disrupting the school, or did it take place in school? So
if as an administrator you hear of an incident on, we'll just stick with Snapchat, and so you make the determination if it's if the consequences are detrimental to the school day in some way. All right. If it is, and you decide to pursue it further, you have to get access to the kid's phone. If the kid has a code on their phone, which I would imagine most do, and they refuse to give it to you, okay, your next decision then is to decide if it's worth continuing. And if it is, you would then go to the police or call parents, or what? I guess going straight to the police sounds a little drastic.
It is a little drastic, and I think calling the parents would be another option regardless of the student's age. But remember, if it is a younger student, then you should certainly contact the parents regardless.
Oh, yeah, I was thinking about high school kids in this particular instance.
Yeah.
Okay. All right. And then the police, obviously, they have their own set of legal guidelines that they can follow. All right. Now, what about searching more physical objects like backpacks and lockers?
Sure. Well, backpacks and lockers are subject to two slightly different analysis. Under Illinois law, school authorities have the right to search school property and equipment owned or controlled by the school. Lockers, desks, parking lots, and then personal effects that are left in those areas. So you can search lockers, you can search desks, you can search parking lots, and I also believe that many schools, when they give students the right to drive their car and park on campus, they have to sign a form in which they consent to searches of their cars. Now, personal effects would be subject to the same analysis as the cell phone. So if a student's purse or a backpack is on their person, you can't just grab their backpack or grab their purse and start rifling through it. You would need reasonable suspicion to even begin a search of those sorts of things.
All right. So what if a student parks on the street to go to school?
Well, if it's on the street, then that would be outside of school property. And depending on what the issue is, again, we're thinking substantial disruption because it's off campus. It may be beyond the scope of what the school can do.
So if student parking overflows onto the street, the town street, then in order to search that vehicle, I mean, if you had a threat, surely can you still search it?
Again, I think it would be subject to – that's a good question. And I think it would be subject to the substantial disruption analysis first. So if there's a threat to the school that day that something in that car would impact the school –
you're probably going to call the cops anyway. Yeah.
I would think so. I think that would be the first step there.
All right. That's just me, devil's advocate.
Well, I like it. It's a good question.
All right. So we've talked about First Amendment, and their freedom of speech. We've talked about Fourth Amendment and searching, whether it's phones, computers. Is there anything out there in the law? Has the law caught up with cloud storage at all?
I have yet to see a case related to cloud storage. So not quite. I don't think it has caught up. But I imagine that could be the next frontier.
Yeah, because, so many schools are Google schools, and so all the kids' files are located in the cloud somewhere. That's, I guess, technically owned by Google, right?
I actually don't know.
Well, for sure. We'll save that for a future podcast then. One more thing that I wanted to touch on is student records. Do they ever, because I know there's all kinds of rules and regulations as far as student records.
Yeah.
When does evidence of bullying, whether it's text messages, I guess I'm thinking more cyberbullying here, become part of their record, if at all?
So if something concerns a student, the student can be identified by it, and it's maintained by the school, then it would be a student record. So when thinking about the bullying context, say that there is surveillance video of a bullying incident, and the school sees the video, and they use that to discipline the student. Discipline one of the students, and the other students just consider the victim. According to a recent federal guidance, that video would be a student record for both the student who was doing the bullying and the student who was bullied. So that's one thing. If you maintain text messages or phone videos that you have received from students, and you use that as part of your discipline, then that would be a student record as well. And then if you use witness statements, if you have different students complete a witness statement about a bullying incident that took place, that could also be a student record.
And so those should be kept. So anytime an administrator takes notes during a disciplinary investigation,